right, joining me now, Robert Ray, counsel to President Trump, and Alan Dershowitz, constitutional representative. What the heck is that? For the president. Alan, the media has been downright hostile to your constitutional arguments. Watch.
I said you didn't need a technical crime back then. Okay, I still don't think you need a technical crime. And I think your viewers are entitled to hear my argument without two bullies jumping on everything I say and trying to pinpoint and nitpick on what I said. Let's talk about what the issues are instead of trying to attack the messenger.
Alan?
Well, obviously, they've been attacking me from day one. They already know what I'm going to argue, and they have disagreed with it because it doesn't matter what I argue. They will, of course, disagree with it. Look, back in 1998, the issue was not whether or not you needed a crime because President Clinton was charged with a crime. The issue was whether it was a high crime. So I didn't do the research. I relied on people like Professor Larry Tribe, who said you didn't need a technical crime. That turns out to be wrong. You may not need a crime. The point, the critical point, is that obstruction of Congress and abuse of power are clearly not within what the framers intended, and I will lay out that argument quite clearly with sources, and I'm sure my other members of the Trump team will do the same.
Now, Alan, why did you want to be called constitutional representative rather than like everybody else? I mean, you have to have a special title. Everyone else is just part of the team.
It's exactly what I did. It's exactly what I did in the O.J. Simpson case and what I did in the second Klaus von Bülow case. I'm of counsel. I have a special role to perform. My role is to present the constitutional argument. I'm not meeting with the team on strategic issues. I'm not involved in whether witnesses should be called or whether facts should be alleged. My argument is limited, as it was in O.J., where I just argued the legal issues. And that's very common. I've done that over and over again as constitutional counsel to big cases that I don't want to get involved in the weeds.
It sounds much more fun than having to get involved in the weeds. You can just quote Charles Pinckney during the constitutional debates, okay? So let's pull out all the delegates and start doing that. Now, I appreciate that, Alan. Now, one specter hanging over the trial is John Bolton's potential testimony. The Washington Post reports Republicans are working to make sure he doesn't testify in public. One option being discussed would be to move Bolton's testimony into a classified setting because of national security concerns. Robert, are you guys worried that Bolton testifies and some real problems for the president?
Why? Because where is that going to take anybody through this process? I mean, the whole point of the legal argument that's been made in the factual record as it exists, which, of course, the House managers are stuck with, is that it doesn't constitute impeachable offenses because they didn't charge and allege them, and they don't have a sufficient case that would warrant removal of the president from office. And, you know, I'm not a constitutional scholar. I'm just a trial lawyer. But as a trial lawyer on behalf of the president taking a fair evaluation of this, you know, let's look at impeachment. What's the whole purpose of impeachment? It's the Democratic constituency not talking to themselves. The only way this works is if a Democratic constituency can talk to the constituency of the other party and convince them that the president should be removed from office. Has that happened here at all, ever? Is it ever going to happen? And the answer is no. So, you know, I don't care how many witnesses you trot out or how many arguments you make, that's never going to change.
Yeah, what are the folks are saying tonight, Alan, Democrats mostly are saying, well, the Trump team legal brief, 171 pages, I haven't gotten through all of it, I've gotten through most of it, basically says, well, okay, he did these things, but they're not crimes, and so he can't be impeached, or he did some of these things.
No, totally wrong. Totally wrong. So, that's not the position. The position is he didn't do any of these things, that he is innocent as a matter of fact. But as every criminal trial lawyer knows, when you have disputes over fact and disputes over law, you always argue in the alternative. You always argue that the facts are not proved, but hypothetically, even if the facts were to be proved, they wouldn't rise to the level of a crime, or in this case, an impeachable offense. So it is not an acknowledgement in any way by anyone on the legal team that the president did anything wrong. That's just not how that brief could possibly be read.
Yeah, here's how one of the MSNBC contributors characterized Trump's legal defense.
This, what I call the "I did it, so what" defense, is actually maybe their best bet for avoiding needing to call witnesses, because what they can say is, hey, if we called witnesses, what would we do that for? All they'll do is tell you what we already are telling you. He did it. He did it, and we just don't think it's impeachable.
Robert.
That's just a lie.
Well, that's just silly, because we're going to be arguing both. And the rejoinder from the Democrats really is, as was pointed out in the president's submission today, they're arguing for an impeachment based upon the president's motives. We don't impeach presidents for motives.
That's a part of your brief. The part of the brief on motive is about subjective intent.
Right.
And
right.
inferring the subjective intent of a president to impeach is something that has never happened. In Clinton, it didn't happen. Nixon didn't happen. Johnson didn't happen.
So it's not, it's a question of it. That's not sufficient as a matter of law, as a matter of the constitutional text, as a matter of historical practice, and as a matter of the framers' intent, and on top of all of that, as a matter of fact in connection with the facts that are alleged here.
And think of how dangerous. Think of how dangerous it is when you start probing the motives of a president. Every president wants to win re-election. Every president makes foreign policy decisions, domestic policy decisions, at least in part to enhance their electability. Are we going to start psychoanalyzing every president's motives and creating impeachable offenses out of looking at the worst possible motives that they might have had? No. You judge a president by his or her actions, and you judge a president by the effect and impact. You don't judge him by looking into the depths of his mind and trying to figure out whether somewhere in the back of his mind he was trying to get some advantage to his electability. That would be so dangerous.
What I've been trying to impart over the last week plus, gentlemen, is this idea that given what we know already about the allegations and the testimony in the House of Representatives, that a motion to dismiss at the outset was almost, I mean, you can't say required, but if you're a good lawyer, to me, that motion has to happen. And for Romney and these other senators who I guess they're trying to play it cute or cover all their bases, I don't know what they think they're going to get here with the, we need to hear from Bolton in order for me to think that there's no impeachable conduct here. There are only 2 articles alleged. Neither article on its face represents impeachable conduct under any sensible reading of our constitutional precedent and the language of the Constitution.
Great.
So why shouldn't there be a motion to dismiss right at the top, either by the Trump team or by a Republican senator?
I agree. I think that that's the right way to go. This is a motion to dismiss case in which, if it were a criminal case and a person were charged, say, with dishonesty, and then there were a list of things he did, the first thing you do is make a motion to dismiss because dishonesty isn't a crime. And obstruction of Congress is not an impeachable offense. And abuse of power is not an impeachable offense. So a motion to dismiss in a perfect world would be ideal, but do the American public want to see an end to the trial so quickly? I think that becomes a political issue.
The LA
well, we don't live in a perfect world. I mean, the point is that I think, and I never quite understood this about the Clinton impeachment, if you're going to have opening presentations and you're going to do that for both sides, and we're going to do this
like summary judgment,
for 24 hours apiece, really a better characterization, if you did it as a civil case, it would be essentially a motion for summary judgment. Right. And in the criminal context, the equivalent of that would be a motion for acquittal, for judgment of acquittal. And I think that the door is still open for that procedurally to happen. So if you don't call it a motion to dismiss and you call it, I think, what it properly is, I think you still are going to have an opportunity to have that motion in conjunction with the question about whether or not there'll be witnesses properly presented before the Senate.
The LA Times is a big story tonight, basically saying Mitch McConnell's trying to rush this, trying to speed this up, to get this thing sped up so fast that we don't really ultimately ever end up hearing from witnesses. Do you think that's fair?
You think there's fatigue now? Wait until the 24 hours on both sides is completed.
Let me just read. The proposed accelerated schedule infuriated Democrats who saw it as a partisan effort to short-circuit a fair trial and to block Americans from following the historic proceedings. Alan, it's up to Mitch McConnell to save the ratings for cable television. It's kind of against my interest because I think Fox viewers really want to follow this because they're so enraged, including at the moderate senators. They're not too happy with them. But is that a fair characterization of what McConnell is doing, trying to bore people to death with this or try to speed it up?
Well, I hope that neither of us here will bore our listeners. I think we will present interesting, compelling, and I hope people will listen, substantive arguments. Whether we present them at 2 in the afternoon or 2 in the morning is going to be up to, obviously, the Senate leadership. You know, I would prefer to present them at a time when viewers are awake and can take in the argument. But my argument and our argument is primarily to 100 senators, and that's our audience, and that's who we're going to be speaking to. They have to be the ones to vote in the end.
So, Robert, you're not speaking to the moderates? That's what everyone said. Not just addressing the moderates. Everyone's saying that.
I think the whole point of this is that there's 100 people there. Why would I choose 4? I mean, we're talking to the and we're, you know, I mean, Alan is right that ultimately, you know, in terms of impeachment and removal from office, we are talking to 100 senators. But really, truly, this is a momentous occasion, and we're talking to the entire country.
Absolutely. Gentlemen, thank you for joining us. I know you got a lot of work to do still before you do your presentations. We really appreciate it. We look forward to talking to you again.